I have a couple of follow-ups on Reagan and Shurtleff. You're relying on those two cases for your proposition that cause could be whatever the person, the authority decides. But Reagan and Shurtleff were very careful in holding that the only reason that was true was because there would be life tenure involved otherwise. It was very careful to distinguish its holding from cases in which there were a tenured position and there was a for-cause provision. So you're extrapolating, correct?
I disagree with that. We read Reagan differently. If you have those two key paragraphs,
we can both look at it.
Don't talk about fixed term at that point.
I think but the court recognized the rule, and I'm quoting from the case, quote, where causes of removal are specified by statute, as also where the term of office is for a fixed period, notice and hearing are essential. Here, you need for cause, and there's a fixed period of tenure. And Reagan very clearly said notice and hearing are required. So if I move on from that, I go back to Justice Alito's question of you. I thought, and the Chiefs, I thought there was a factual dispute. As I understood it, Ms. Cook's letter, her attorney's letter, and quite frankly, I've never understood that a letter from a lawyer wasn't a representation by a client. This is a new standard I've never heard of before in an informal proceeding. If the president can go by social media and one believes that that is adequate notice under law, I'm hard-pressed to think a letter from a lawyer is not notice from the adversary. But we can move on from that. The letter from Ms. Cook says, the Michigan bank gave me permission to rent because I got a job in Washington. I had to move from New York when I got my job in Washington, and frankly, I renovated my apartment the year before, thinking I would be in New York for the rest of my life. Things change, and the bank in Michigan, at least they represent, will say there was no deceit of them. As to the mortgage issue in Atlanta, Ms. Cook's lawyer represents that the paper submitted to the bank disclosed the fact that this was a vacation home. So they may not have experienced deceit. If they didn't experience deceit, then you're left with gross negligence, and the question becomes, is it grossly negligent to make a mistake on a mortgage application? And I don't know that gross negligence has ever risen to the level of a mistake. So there is a factual issue. Now the question is, who resolves that issue, the level of review of that decision, and those are all questions, as Justice Alito pointed to, have not been addressed below, correct?
What was addressed below is, I think, exactly what
just a due process right to
Alito.
Notice in a hearing by the circuit court, and for cause being something that has to be only what's at the time of in office. I do agree with you. Common law did permit pre-office conduct to be considered, but only if for an infamous crime. I don't think this rises to an infamous crime.
If I could say two things about that. First, on the narrow point about whether or not a letter of counsel can create a factual dispute in this context, that's the holding of this court in Codd against Velger, where the court said that suggestions of counsel are not enough. It's the party who has to do it. So there were representations of counsel there, and the court held that that wasn't
That's
enough
in
to
a
create
legal
factual
proceeding. This is an informal proceeding. Legal proceeding.
Yeah, the point was there had never been any representation by the party in any context, formal or informal, and that's exactly what we have here. That's the one point. I can't remember the second point I was going to make in response to that.